everyone. So my name is Sam Lednicki, and I've been doing this clinic for about 3.5 years now, almost every month. Recently, I've been doing it a little bit less because of work commitments. But essentially, Maggie has asked me to do a little bit of role play and sort of give you a really good idea for what actually happens in the clinic from the second you arrive to the second you go in front of the court and you move to withdraw. So you've already heard about 2 hours of content, and you have this really thick book with the law and cases and all that. And so my job is to condense those 2 hours into the 10-minute interaction you have with the tenant, the 5-minute interaction you have with opposing counsel, and then potentially walking through a contested hearing. So I'm going to try to do that all in about a half an hour, so then we can leave some time for questions. And I'm going to keep it pretty simple. It's just going to be one count for non-payment of rent. The no-cause issues and the breach of the lease agreement really come up less often. And I'm also going to keep out habitability issues because that will make the scenario a little bit more complicated. So I just want to start with giving you a rundown of how I approach the cases, how I approach my meetings with the client, things to look out for, things to do, and then we'll get right into a role play. So in your packets, you do have this rent escrow checklist, and I don't know if Maggie sort of already went over with you what it is, but this is a basic guideline for kind of the questions that you want to ask your tenant. I haven't actually ever gone through it question by question, circling it, but I think it's a good thing to look at before you meet with the tenant to really try to focus the conversation that you're going to have. So I like to, I've only done them here in Chittenden County, so it's usually Maggie or Angela, Angel, who assigns, they say, tenant's here, they said they want to speak with a volunteer, go. So we'll get the court file from the court clerk or from Angel, and the first thing I want to do is introduce myself. So, hi, I'm a volunteer. I understand that you'd like to speak with someone. My job today is just to represent you in today's hearing, for the limited purpose of a rent escrow hearing. So I'm not here to help represent you throughout the case. If this case goes to a contested trial or a jury trial, I'm not telling you today that I'm going to represent you through that process. And then if they say yes, they want to meet with me, they want me to represent them, we kind of go from there. And oftentimes the tenant has paperwork with them, they're flustered, they're upset because what's already happened before you even see them is they've been noticed with a letter for termination of tenancy. Most of the time that'll come through certified mail or hand delivery. But then they're also served by a sheriff with a complaint for eviction. So those two pretty concerning events have already occurred, and so usually they're coming to you not in the best mood. And most likely they've had a contentious relationship with their landlord or their landlord's attorney also before they meet with you. So I like to introduce myself and say, I'd really, really understand that you have a great story to tell me or an important story to tell me, but if you can just give me a few minutes, give me 2 minutes to just review the court file. So I have the court file. Most of the time there's some tabs in it that'll say complaint, answer if there's an answer, lease agreement. So you can pretty quickly kind of thumb through it just to check that everything's there. So if you go back to the statutes, you know that attached to the complaint has to be the lease agreement. There has to be, if there is a motion for rent escrow, and in all cases in which you'll be meeting tenants, there will be a motion for rent escrow before you. An affidavit from the landlord has to be attached to that and signed and notarized. So those are sort of the key things. Look through, make sure they're there. Also check to see if there's an answer, because most of the times, if there is an answer, you know that they've either already met with legal aid or they're really on top of this and they've filed some sort of handwritten response to the non-payment. And you can usually indicate it in that there'll either be some type of counterclaim, it probably won't be articulated, specifically with factual basis to back it up, but there'll be some information in there to kind of tee you off to where to focus the conversation. So just thumb through, make sure the paperwork is there. If something's missing, note it. Then I like to go through the complaint and just see how many counts are alleged. So non-payment of rent, count 1. I have seen some attorneys also have this second count that says if something along the lines of, when the tenant moves out, if there's damages, I'd like to collect on those damages. That can usually be disposed of by a quick oral motion to dismiss. There has to be very specific factual allegations that damages have occurred at the time of the filing of the complaint. You can't allege, sort of future, and at least in front of Judge Torr, she's granted those requests. So see what the issues are. That also shows you how to target your conversation. And then the next thing is that really important notice to terminate. So I did include, I think Maggie included this notice of termination quick guide that I made. You're going to want to go right to the chart. So there's this little chart, and on the top it says whether it's a written lease or a non-written lease. And then it says the type.
Did you say it's behind the PowerPoint presentation?
Yes, it's behind the PowerPoint presentation. Behind it or in front of it? No. Okay, well, if you don't have this, I can share it with you guys again. But for the notice of termination, I look to the date at the top to see the date that it was written. Now, that's not always the date that it was sent to the tenant or provided to the tenant, but that gives you a clue for when the landlord is starting to send this out. A lot of times, a good landlord's attorney will include, attached to that notice of termination, a certified mail receipt. And so if you see that there's a tenant's signature on that, that gives you a clue that they did receive that notice of termination, that they've actually signed for it, they went to the post office to pick it up, or their mail person, provided it to them. And as I'm flipping through, I usually ask a few quick questions. Can you just confirm, is this your signature? Have you seen this piece of paper before? And if they say yes, yes, you're like, okay, next issue to kind of quickly look for. So once you figure out why they're being evicted, if there's a written lease, if there's not a written lease, you go to your chart, okay, 14 days. So there's a written lease, this tenant has been here for more than 2 years, and it's a non-payment of rent issue. So was the notice served, or was the copy received within 14 days of the date of the notice of termination? And if you're within that window, so if the date that they signed that certified mail receipt is within 14 days of that date that allegedly their tenancy is terminated, then that's an easy issue to challenge at the rent escrow hearing. So I won't go through kind of all of these things because you have it in your materials, and Maggie and Nadine went over it with you today. But first thing to do is really start targeting what issues are you going to challenge and what's there. And the best way to do that is look through the court file, because the court's going to have the most accurate information about when things are filed. You'll see the filing stamp of the complaint. That date that the complaint is filed is really important to assess how much rent is at risk of being due very, very soon if you were to lose at a rent escrow hearing. As well as the service date. So they'll also be included in there a return of service from the sheriff with the date that that was served. And so the statute says that it's whichever one comes first. Most times the complaint's filed and then it goes out for service, but under the rules you're allowed to do it in the reverse. So just make sure you're seeing which date comes first. Notice of hearing is another important document to look for in that court file. The notice of hearing actually has to be sent to the tenant 14 days prior to the court date. So usually the clerks are really good about making sure that these notices get out to the tenant in the mail, and they receive it well before a 14-day window. So you have to have those 14 days. And now our rules are calendar day, a day is a day. So I used to make some arguments when it was 10 days, that those were 10 business days. I don't know how successful I was, but I'm of the philosophy that you identify every possible issue that there is, and you raise all of those issues, because it's really the worst case scenario that you have to go forward with a hearing and contest the issues. The best case scenario is that you're able to negotiate something that both is favorable to the tenant and the landlord is agreeable to it. So looking for the complaint, looking for the notice of termination, the notice of hearing, as well as the lease. So leases are usually multi-pages. You don't usually have a ton of time to review every word in a lease agreement. So my advice is really just look for the term of the lease. Is this a one-year lease or is this month to month? the amount of rent. So as I'm flipping through, one of the quick questions I ask is, tenant, do you agree that your rent amount is $1,200 a month as it's written in the lease? Sometimes the answer is no. Sometimes, oh no, for the past 5 years I've been paying a lot less than that. So that's an issue to target. If one of the counts in the complaint is breach of the lease agreement, then you're going to want to look through the lease in a little bit more detail and spend some quality time on what is it. Are they alleging criminal activity? Well, that's an easy one to analyze, but if it's some breach of some other term of the lease, then you're going to really want to read through that lease term. And then finally, always the term that I'm looking for at these hearings is there an attorney's fees and costs provision for breach of the lease? So if someone hasn't paid their rent and there's an attorney's fees provision, if one party is to breach, that's important to try and negotiate to get the landlord to waive that. So court costs and attorney's fees can really stack up in these cases. And if you're able to come up with a payment plan, you want to see if you can also negotiate having the landlord waive those. That's also a risk that you're opening your client up to in the future if you were to go forward with contested hearings or potentially request a jury draw. You know that the attorney's fees are going to stack up in those cases. When I get into what to ask the client about, asking them if they're judgment proof, and you don't say that, but you kind of get a quick idea about what their income is, if they're on any subsidy, what's going on with their life. Are they currently employed? Did they just lose their job? Are they expecting a big tax refund? That's a big one around this time of the year. So I'd like to just dive into a case now that you kind of know what to look for in the court file, so you can see how I approach the cases, and then when we're done, I'll ask for questions and we can ask me anything you guys want. So I just received the court file and I'm looking at the name and it's Will. So Will, would you mind stepping up? And do you want to take a seat in the conference room for me? All right. So hi, Will. My name is Sam Lednicki. Nice to meet you.
Hi,
I'm
Sam.
a private attorney, but I volunteer my time today at the Rent Escrow Clinic. So do you know why you're here today?
Well, I mean, not really. I understand that my landlord is suing me for eviction, but I've never been through anything like this before.
Okay.
Yeah.
Great. Well, I'm going to try to do my best to give you a brief overview of the process and what today's really about. So I'm here to represent you just in today's hearing. So that means at the end of the hearing, I will withdraw and you will be entering your notice of appearance on behalf of yourself. Mm-hmm. So we'll go over a little bit of paperwork. That'll probably be the last thing that we do. So today's hearing is called a rent escrow hearing. So what your landlord is requesting, and I'm going to go through the court file really quickly and see exactly how much money is at risk today. But what your landlord is doing today is asking for money, your rent amount, to be paid into court for as long as this case goes forward. So you are entitled to have a hearing. You're entitled to dispute what your landlord alleges is in arrearage, or the issues that have gotten you here today. But as this case plays out, you could be liable to be paying rent into court, and the court keeps that money. And at the end of the case, if you're entitled to get some of that money back, the court would reimburse you. But if all of that money, if the court decides that that money goes to the landlord, it's going to go to the landlord. So let me just really quickly read through the case file, and I see that you did bring some paperwork with you. Is that what you were served with by a sheriff?
Yes.
Okay.
Yes.
So if you want to hang on to that stuff for now, I'm just going to peruse. All right. So I see we have a complaint here. Do you agree that the rent is $1,200 a month?
Yes.
And I see you have a written lease agreement. Is
Yes.
that correct?
Yes.
Did you sign that written lease agreement?
I did, yeah.
Has it been amended in any way since?
No, I don't think so.
Okay. And you are currently in your term of a 1-year lease.
Yes.
So this expires in June 1st of this year?
Yes, that's correct.
Okay. All right. So I'm looking at the complaint here, and there's one count of non-payment of rent. So what your landlord's alleging here is that you're in arrearage about $5,000. Is that accurate?
So I don't agree with that. I've been able to pay the landlord something in the past couple of months. So what happened was back in November, I was hurt. I had a knee injury. I had to go in for surgery. I don't get any sort of paid leave for my work, so I was just out, not having anything coming in for about 6 weeks.
Okay.
And then in December, I was starting to be able to go back to work, but I needed to put a bunch of money in my car.
So would it be fair to say that November 1st was the last rent payment, or was October 1st the last rent payment you made?
October would have been
Okay.
the last one.
Okay. And you paid the full $1,200?
Yes.
And do you think you were behind at all before October?
No, I don't believe so.
Okay. All right. So let me just keep looking through here. All right, so I do see that you have a written lease, and it does provide for an attorney's fees provision, so that's good. That's something to note here. All right, so this is a pretty important document. I'm going to show you this. It says Notice of Termination of Lease. Do you recognize this document?
Yes.
Okay, how did you receive this?
So this was hand-delivered to me by the landlord's property manager.
Okay, all right, and that was delivered to your hand?
Yeah,
You received
yeah,
it? Okay.
yeah.
All right, so this is for non-payment of rent. Oh, and do you reside in Burlington? Let me look at do you agree that this is the address that you live at?
Yeah, that's the right address.
Okay, so
Yeah.
it's in Burlington.
Yeah.
Okay, all right. So let me just read through this agreement. All right, so they're claiming that there's about $5,000 in arrearage. You actually pay $1,200 a month. Does any portion of your rent get paid by a subsidy or any other
No.
party, so you
No.
pay it solely? Okay. All right. So now that I've reviewed the court file and I see all the documents in here are here, tell me a little bit about what else is going on. Do you have heat and hot water in your apartment?
Yes, although the windows are not. The windows are just single pane. It's pretty drafty. I'm responsible for heat, and I spend a lot of money on heat.
Okay, how much do you think you spend a month on heat on average?
So it's electric. My electric bill is pretty high. I would say probably about $200 a month, something like that. Yeah.
Okay. Have you raised that issue with the landlord?
I have talked with them about that. Yeah.
Okay. Now, I know this is probably hard to assess, but do you think the heat's over 60 degrees Fahrenheit in the winter?
The thermostat says so, but yeah.
Okay, but still pretty drafty.
Yeah.
All right, and you have sufficient plumbing, you're able to use your shower, bathrooms?
Yeah, the issue with the bathroom is there's a fan in there that doesn't work, so it gets pretty mildewy, pretty gross.
Okay.
Yeah.
All right. All right, so these are all certainly issues that we can raise as a reason for maybe only making a partial payment.
Okay.
But from what you told me, I don't think you have a basis to withhold all of the rent.
Yeah.
So we may go over this in a little bit more detail if we have to go forward with a contested hearing today. All right, so what is your goal? Do you want to stay in this apartment?
Oh yeah, it took me a long time to find it. It's a good location for me. I do want to try to stay there.
Okay, all right. And do you have any ability to pay some of this arrearage?
I've really gone through all my savings. I mean, I'm back at work now, but as far as paying anything above my current rent, it would be really hard. I am waiting on my tax refund. I don't know when I'm going to get it. I just filed the other day, so.
Okay. How much are you expecting?
I'm expecting to get probably about $1,500.
Okay, so that's about 1 month of rent
Yeah.
that we can offer. Now, you said you probably don't have enough money right now to pay any of the arrearage. What about the next month? So April 1st is coming due pretty soon.
Yeah,
Do you have an ability to pay $1,200 on April 1st?
I think so. Yeah.
Okay. All right, so that's good to know. But you don't have anything else kind of saved up today? You
No.
didn't bring any with you?
No.
Okay. So what I'm going to do is, I see that Nadine Seebeck is the opposing counsel on this case.
Okay.
So she's outside. I'm going to take a minute to go chat with her.
Okay.
I'm not going to agree to anything, but I'm just going to get a sense for whether or not they want to pursue the motion and whether there's any wiggle room on how much you're to pay and whether or not they would agree to just start the rent escrow payment starting April 1st. Is there anything else that you want to tell me about your living situation? How are you treated by the landlord?
I mean, I think up until this happened, it wasn't a bad relationship, but I don't know. Yeah.
All right, well, you hang tight for a minute and I'll be right back.
Okay.
So that's just sort of a basic interview. So what I would do next is I would meet with Nadine. I just used her name. what I'm looking for in my negotiation with the opposing counsel, really it's just sort of a first initial meeting with them. I want to know, A, are they going to move forward? Do they want all rent that they're entitled to seek at today's hearing? So the complaint filing date, say it was February 1st. They'd be entitled to claim all of February, all of March, because March became due on March 1st, and then April 1st payments going forward. So I would talk to her, I would see if there's any wiggle room, if they really want to go through and or they want to pursue the hearing, or if it's more appropriate to set up a payment plan to start the rent escrow starting April 1st, or do some sort of combination. So if I go back and actually, oftentimes I go to the landlord and I hear a whole different side of the story. So, my client just represented to me that no, there hasn't really been any issues, but I go talk to the landlord's attorney and they're like, listen, this guy is bad news. He's been having parties every single night. There's always people coming in and out of the house. We're really concerned about the other tenants who live around them. It's really our goal just to get him out, right? And so, so then I'm armed with a bunch more knowledge to come back, and I like to also make sure that you get the accounting. So if the landlord's not ready today to present you with an accounting, sometimes that's a reason to continue the hearing, but because you are representing them for that hearing, I like to see how much we can get accomplished. Because if you send them on their way with a continuance, they're going to be back in this situation, and you're not staying on to help them resolve the issue. However, if there are significant issues, you can refer them to legal aid who may be willing, or you can talk in Dave's ear and get him to take over a case for you. All right, so we won't do the role play with negotiating. You guys all do that, I'm sure, in your regular practices, as we work with opposing counsel all the time. So Nadine has told me that, unfortunately, her client is a stickler, and he hasn't gotten a rent payment since October, and we're now in March, and he really just wants the client out or to pay up. So, hi Will, how are you doing?
I'm okay.
All right, so I wasn't able to make a ton of progress.
Okay.
It does sound like your landlord is pretty strapped for money because this
Okay.
is one of his few rental properties, and you do agree that you haven't paid since October.
Mm-hmm.
So what I'd like to do is see if there's any issues that we can challenge to go forward with a hearing. But I
Okay.
want to explain to you what that's gonna look like. So if we go forward with a contested hearing today, your landlord has the burden of proving that you're obligated to pay rent and that you've failed to pay rent. So they'll introduce the lease agreement, they'll testify that the rental amount is $1,200 a month,
Mm-hmm.
and that you've failed to pay that since October.
Mm-hmm.
Now, because you would also credibly testify that you haven't paid since October, we really don't have a lot to go on. But I did notice in reviewing this notice to terminate tenancy that they actually include some of the water bill in here. And they've also included a late fee. So what I'm going to do is I'm going to make some legal arguments to the court that that was inappropriately added, and that doesn't give you notice of how much you need to pay to be current. So what this will do is it won't resolve the case. What it'll do is it'll dismiss the complaint, but your landlord's attorney has represented to me that she's just going to refile.
Okay.
Now that she's representing your landlord, she's going to do everything that's proper and cure that defect. And so it will result, hopefully, in dismissing the case if the court agrees with our arguments. But they're going to bring the complaint again, and you're going to be in this situation a little bit down the line. So what I'd like to do is refer you over to legal aid after this, and
Okay.
also refer you to an organization called COTS. So I have this resource list here. Have you ever spoken with any resources about getting paid? So
No.
a lot of times they'll offer you some money that'll go directly to your landlord to get you paid up. So your job is going to be, after this hearing, to meet with legal aid, meet with some of these resources, and see what you can do on your own to get paid up, get current, and hopefully prevent your landlord's attorney from refiling the complaint.
Okay.
Does that sound like a plan?
Yeah, thanks, Sam.
And if you do get service of a new eviction complaint and a new notice of termination, you're going to really want to start thinking thoughtfully about what your next move is. If you can
Okay.
start looking at apartments, trying to get out and not be left without a home.
Okay.
Okay? All right, so let's go head in there and get this case dismissed.
Okay.
All right. So, so that's, you know,
I'd like to know the rain notices would never have.
yes, that's why I clarified, this was sent by the landlord directly, not by a council. So that's just like a quick one, but you can see that you can get a lot of information out in a really short amount of time. It would obviously take me a little bit longer to read through the court file. And you know, once you do these a lot and are comfortable flipping through the file and looking for the specific dates that you need to look for in the documents, it gets a lot easier. So does anyone have any questions? I guess if you want to sit down, I'll invite
Yeah.
Maggie and Nadine if you want to chime in as well. Yeah.
So in my limited experience
Yeah.
in these rent escrow hearings, he's an exception. He was a really good yes, no. Mostly people are crying or they're
Yep.
really mad and they're
Tissues are
focused
prevalent.
on 1 or 2 or 10 details.
Yeah.
How do you deal with that?
Sure, so I'll just repeat the question in case the mic can't pick that up. So how to deal with clients who are really emotional? Well, I don't know what percentage of clients I deal with that are emotional, but it's a lot. You know, as I was saying, you're dealing with people who are in a very bad situation. They're at risk of losing their house. And a lot of times when they get these eviction complaints, they think that's it. They could be out in a minute. So, you know, I think it's important just to speak to them like you would want to be spoken to when you're emotional, you know, telling them that this is really just the first event. This isn't the end of the road. You have an opportunity to tell the court what issues you dispute, but letting them know that it's really important for me to do my job right if I can look through the court file, because you really need those first few minutes to do that. And I guess my advice would be, if you really think this person is just going to keep diving in and interrupting you and you won't be able to process the information in the file, to go look at the court file before you meet with them. And I think, you know, you can assess the client's well-being sort of when you see them. And so if someone tells you, okay, that's your client, you know, all right, tell them I'll be with them in 1 minute. Okay, I'm just going to go into the courtroom. And then sit in the court and look through the file and try to target the issues before you go talk to them. But yeah, I mean, I think you all know that a lot of our jobs sometimes is being a counselor and having patience and really listening. I have had some cases where the client just won't listen and they're like, I need to tell you my story. It is important. And then it's a judgment call and you say, all right, I want to hear your story. Can you condense it to me in 2 minutes? And you just have them go through what they want to get out.
I always have tissues. I mean, the reality is that a lot of people that are coming to court maybe they've never been to court before, or if they have been to court, it was not a great experience. And a lot of people are really afraid. And so, rightly so, right? They might be losing their housing. So one of the things that I say to people, that if I can tell that there's a lot of panic or emotions kind of getting ramped up, I always say it like, this is the rent into court hearing. No one's paying any money today. Nobody is moving out today. Because sometimes that needs to be said out loud. A tenant might think like, there's going to be an order kicking me out this afternoon, or if I don't have $2,000 right now, it's all over. And, you know, that's something that we know. You've been trained, you now know that too. But your client might have no earthly idea what to expect. And I think just letting them know that, you know, catastrophe is not going to happen this afternoon sometimes helps them be able to hear you a little bit better. Because I don't know about you, but when I'm stressed out or nervous, I'm not taking in any information. It's really hard to learn. And part of our job at the clinic is to not only give some legal advice and counsel, but sometimes you're explaining the eviction process to someone and need to take their guidance. That's very difficult to do. So trying to sort of take out some of those really fearful things up front, I think has helped a lot.
Yeah, that's true.
Any other
I was
questions?
gonna say too, you never know what your client is gonna do. I mean, I see it from the other side, and I talk with tenants every day, and You can have mental health issues, which are prevalent in this area of the law. You can have language barriers. We just had an interpreter here on Tuesday. So you have all sorts of things that can be going on. And we had a bunch of babies here on Tuesday, and it's chaotic. It's crazy. And there are a lot of tenants who think that I have to be out tomorrow. I had a tenant from Texas a few years ago that he calls me up. He's like, Nadine, don't throw my stuff out on the street, because in Texas, literally, they go in and they throw your stuff out on the street. And I'm like, no, this is Vermont, and there's a process, and you've got some time, but you need to figure out what you want to do. So you just never know what kind of tenant or client that you're going to have on a daily basis.
Time is really on your side. I mean,
In the state, yes.
in the state,
Time is on your side.
you know, just anything that you can do to kind of, if you know that your tenant does not have any ability to pay, the only thing you're really here to do is get them as much time as possible. So, I mean, if it's negotiating the first payment date out a month, or if it's pleading that to the court, if you know that, something I always ask my clients is, well, when do you get paid? Do you get paid every Friday, every other Friday? When is your next paycheck coming in? And then you can relay that information to the court, saying, instead of issuing it this Friday, can you issue it the next Friday when they get paid? And it'll give them a little bit better of a chance to
I mean,
get the
do you
money.
find that landlord attorneys are willing to work with you on dates, on escrow orders?
Most of the attorneys, yeah. I mean, I think we have a good bar here in Chittenden County. I find more it's the landlords themselves that are a little bit more frustrated, because they've been dealing with this tenant for the past 2, 3, 4, 5 years, and it's sort of this constant struggle to get those payments, and they're the ones that are insisting, no, I want it all now, no, I want them out. But you guys all do a great job explaining, well, here are the risks and consequences, and if we're gonna bring counterclaims, or if there is a viable challenge to the complaint itself or the affidavits, they understand that.
Right.
Any other questions?
Could you talk a little bit more about the income that is not collectible? And, if there's a resource of how you would know what falls into that category?
Sure. So everyone that's going to get help from the clinic fills out an intake sheet, which asks what their income is. And my office is, we're grant funded and can only help folks below a certain income level. So that's why we need that information. But that will tell you, they'll fill out, and if they don't fill it out, we usually try to, check in with them and ask for it. But there are certain benefits that just because they're that benefit, a court is not going to compel payment out of, like, a Social Security payment, a veterans benefit, workers' compensation. It's all that, those are in the statute. Reach up, yeah. But the unique thing about benefits, so those benefits are usually a cash benefit, they're not collectible. But if someone receives 3 Squares Vermont, which is food stamps, if they receive that benefit or also receive some health insurance through the state, those benefits, I explain to clients, sort of act as an umbrella and cover all of your earned income. So there are folks that are working, maybe there's multiple people working in the household, but they're earning a low enough amount that they still qualify for those benefits. So if you are earning wages and still qualify, those will protect earned wages from court judgment. So that means, the court could agree that, yes, you owe all this money. Yes, the landlord wins. They have a money judgment, but when they go to enforce it, they're not going to be able to enforce it. The court won't compel payment out of those sources.
And I've had cases where I've had both tenants working, husband and wife working, and we didn't get a garnishment order. They just didn't make enough, or they had too many expenses related to their children, and the judge was not willing to issue a trustee process order.
And I don't remember what the earned amount is. I want to say it's in the statute, but I think if you're earning under $290 a week, but don't quote me on that, I think if you're earning below that, then again, trustee process won't issue against you.
40 times the minimum wage.
4 times the federal minimum wage.
There you go.
Yeah.
Okay.
So, I mean, a lot of times, armed with that knowledge about what their income level is, you can go back to the opposing counsel and say, listen, even if you win and you get a judgment against them, it won't be collectible. Why don't we negotiate 60 days and we'll give you a writ of possession after those 60 days? And so that gives the tenant enough time, but often even 60 days is not enough time to find a new place to go. But it gives them the longest period possible, because usually a rent escrow, the amount from the date of filing to the date of the hearing, the court is likely to issue that all that become due in about 10 days. That's sort of the worst case scenario that I tell the tenants. Some judges, I think we've seen 5 days, depending on how much that is. But it's up to the judge's discretion to order that amount due and within any period they choose. So I always argue for 10 to 14 days. Landlord may argue for 5 days, and the judge is going to do what's in their discretion. So if you can negotiate that.
Flexible. If
Yeah.
the tenants don't show up, it's, Judge Torr is 5 days, some judges are 3 days, I think Judge Teachout's 5 days. So if they don't show up, it's a very quick amount of time from service that they have to get the payment to the court.
But you still have to send that order out for
Right.
service, which is good, because that allows another 5 days or so. I think what the courts are now doing is if the tenant does show up, that they are asked to accept service here in court.
Oh, they do. It
So-
ends up costing them more money, because then there's going to be a service fee
Right.
in addition to that. Just keeps costing them more and more.
Right. But then I guess you waive that 5 days that it may take to get service out to you.
Yeah. And usually if you come in the escrow, I don't find that, usually the tenant will have the money if they can pay it in 5 days. If they don't, usually the order's for a longer period out, so they can come up with it. So if you're negotiating the escrow order, I think that first order, if they just don't have the money, they don't have the money. But if they're gonna have the money, usually negotiate it that they can make either the first payment, the second payment, and the goal is that they can continue to make the payments to the court until there's a final hearing or some other resolution to the case before then.
So I have a few comments, if there aren't other questions right now.
Yeah. She's like hiding in the back, I didn't even see you back there.
So, first of all, just on that last point, you can always ask for anything in terms of the payments, right? You can ask that they be, every week instead of one big payment, even though it might sound better to have the payment in a month. Sometimes the money disappears between week 1 and week 4. So if they're paying a little bit each week, maybe they'll get it done better. And the point about, how long until the first payment is due, if there's a reason to give you 2 extra days because that's when you're getting your paycheck, that's a really good argument to me, that they won't have it on Thursday, but they'll have it on Monday. It makes a difference. So don't hesitate to ask your client, is it going to, and sometimes I'll ask that question, is there a difference between, Tuesday and Friday? Does it matter? Are you going to be able to come up with it? The other thing is that I urge you to think about the long-term picture when you're having these meetings. So a lot of times these cases are resolved right at the rent escrow hearing, because if your client says, you know what, I'm leaving, I don't want to stay there, I have an apartment lined up in 2 months, there's no reason to be having this case go on for months while we're fighting over this, if everything is clear. Even if you don't have the time or the ability to actually come up with a final judgment agreement that day, I'm always going to ask, what's the plan? Where are we headed? What do we want to do next? Because my view is, I like to always have a next date scheduled in the case. And so I want to know, are you hoping that you're going to come up with the money and work it out? Are you really planning to fight this? Are we going to need a trial? If you know that, it gives us a plan to schedule what happens next. So I'll ask those questions if you don't tell me. Also, I don't know if this was mentioned because I wasn't here for the first part of the training, but did you talk about challenging habitability at rent escrow hearings at all? So different judges have different views about that. I do let you do that. It will potentially affect the amount that I order to be paid, but it's going to be a relatively condensed hearing, but you can certainly raise those issues. Also, if the rent escrow motion is filed later than the complaint, which sometimes makes sense for a landlord, there are reasons to do that. Did you talk about that at all? So, the landlord might file the complaint, the person is someone who they expect might just leave, the case is done, they don't necessarily need to do anything further. They wait and see, then that tenant does file an answer, is challenging the case. At that point, it makes sense to file the rent escrow motion. For me, the impact of that is you can argue to me that the amount of the first payment should be lower because the time that the motion was filed was later. So even though the statute says the time of the complaint or service, if they waited 2 months to file the rent escrow motion, to me, it's not fair that that 2-month period should be part of what the person has to pay up front. And sometimes there's also a delay because of the time it takes to get service. And depending on why that happened, I mean, if it's the affidavit from the sheriff that says, the defendant was hiding inside, I could see her peeking out through the curtain, and, she said, go away, I'm not taking the papers, I'm going to look at that one way. But if they just couldn't find the person because they're at work all day, I'm going to look at it differently. It's not their fault necessarily. Why should they get burdened with a much bigger first payment? So you can make those arguments. Also, interpreter was mentioned. In case you don't know this, if you determine that your client has a language barrier, we have the ability to immediately get an interpreter on the phone. We have an 800 number service that we call. I don't actually know how that works out there, but there are phones in the attorney rooms, right? No, there aren't. Okay. But if it's necessary, you can always, I have done this, if you need to have a conversation with a client with an interpreter, we'll find a way to make that happen, whether that's, down at the front counter or we step out of the courtroom. We have a court officer room with a phone we can take you back to. So if that's necessary, talk to the court officer about it. We'll make it happen. And we provide the interpreter for the hearing as well. Just so you know, the policy is when there's a contested hearing, we're supposed to have live interpreters and things like status conferences. We can use the phone. However, these hearings, there's no way we're going to get an interpreter if we just found out. But if it really is a significant hearing, there are habitability issues, this person doesn't understand English at all, you can ask me to reschedule the hearing to get a live interpreter. So that's something to also be aware of. And finally, just a couple comments. Great presentation by Sam, but I want to flag two things that I want to remind you of. Really common feedback I have for lawyers, try not to use legal language. I'm not sure arrearage is a word that most tenants are necessarily going to understand. I try to make things really simple, the money that they say you owe them. So keep in mind the terminology issues. And also, she sounded darn sure I was going to grant her motion there. I'm not sure I would tell your client that today we're going to get this dismissed. You might say, we're going to ask the judge to dismiss it, but you might want to tell them, like, plan A and plan B. If the judge dismisses it, this is what will happen. If we don't win, here's what will happen. And I'm sure you would do that.
Sure, I would in person.
Sometimes you can, if you know me well enough, you might know what I'm going to do. Also, if it wasn't mentioned, those of you who volunteer, there is no minimum amount you have to volunteer. If you come once a year, that's great. I'd much rather have you more often. If you want to do it once a month, if you want to do it for each clinic, every couple of months, whatever works for you. We're not mandating a certain minimum. Although you'll get more comfortable, obviously, if you do it more often. And lastly, I mentioned this earlier, but the whole idea of civil Gideon and trying to get more lawyers for people without the ability to afford them, you're all younger than me. You got years ahead of you to fight this battle in Vermont, so take it up, please. I know there are a lot of other things, like climate change. You all got to work on that too, but please try to support those kinds of attempts. It's really, I think, a really important thing that doesn't get enough attention. So do you have any questions for me before we tie it up? Yeah.
So a landlord who texts a notice to quit, I hear about this.
Text it?
Yeah, text.
Oh, well, isn't that interesting?
Yeah, or
Oh.
email.
The
Interesting.
question
And then
is about a
tries to
text
come.
and notice to quit or an email notice to quit.
Right. And then tries to file a court-ordered eviction, and the court knows that there was a text.
I have never had that raised. So I would have to think about the implications of that, but you could certainly bring up an argument with me. I don't remember that ever coming up.
We hear about that.
Yeah. Yeah, no, there might well be some legal argument that you could present on that.
Especially if there's that, that option when you're texting that says that the other party did receive it and looked at it.
I mean, I think until the law changes as far as actual notice is hand delivery or first-class mail, until the statute changes.
Well, that just gives you the presumption, though, right?
The statute was written before email and texting.
It was.
So if you read the statute strictly, you would say writing, in the same way you'd say writing for notification of a problem with habitability. But the world has moved on, and in some fashion, email and texting is even more reliable than something sent to the US Post Office. So I think it's a good argument, I just don't know which way you do.
So he's making your argument, Nadine. Yeah, no, it is true. All of these things are changing, and there are times I've actually allowed service of a complaint by email once, based on specific facts, and I've seen that done in other jurisdictions as well, that sometimes it's actually more reliable than other ways if you can document the receipt and so forth. But yeah, the world is definitely changing. Other questions? Okay. Well, thank you all so much for doing this. Do you have any final things you wanted to say,
I
Megan?
don't think so. We just hope you volunteer, and you can contact me or Angel, and we look forward to seeing you guys in court. I did also want to point out, Sam's handout did not make it into the binder. It will be in all the other binders. I will send it to everyone here, so you will get it, and I'll tell you where to pop it in.
And Michael, where's our sign-up sheet?
Right outside.
Oh, good. So
Yep.
please stop at that little table. Thanks, everybody. Hope
Thank
to see you in
you.
court.
Yes.